Thank you for joining us as we review the Tarion application process for common elements parcel of tied land, vacant land, and low-rise condominiums. Please note that the information contained in this video is general in nature and does not take into account any particular requirements or circumstances involved in a specific application. When you are ready to apply to Tarion, you should first review the written version of Registrar Bulletin 10 located on Tarion's website, which details the complete application process. If any information conflicts with the Ontario New Home Warranties Plan Act or associated regulations, vendor-builder agreements, or registrar bulletins, the latter sources prevail. Also, this overview is not taking into account any registered condominium conversion projects, which is when the pre-existing elements of a previous structure that was non-residential is being converted into a residential dwelling, such as a factory or a church. The Tarion application process that we are reviewing today applies to newly built condominium construction, and should you have questions about registered condominium conversion projects, please contact us. Effective February 1st, 2021, the Home Construction Regulatory Authority, or the HCRA, assumed Tarion's previous role of licensing new home vendors and builders. This means that a person who plans to build and sell a new home in Ontario must be licensed by the HCRA, and that the HCRA is responsible for granting new licenses and renewing existing licenses. In addition to licensing, the HCRA is also responsible for investigating honesty and integrity complaints made about vendors and builders' conduct and includes illegal building practices. The HCRA also manages the Ontario Builder Directory. Tarion continues to administer the warranty claims process and backstop vendors' warranties where they fail to resolve warranty claims. Tarion is also responsible for authorizing construction and sales plans of licensed vendors and builders via the Qualification for Enrolment, or the QFE, and enrollment processes of homes in the Ontario New Home Warranty and Protection Plan, and we'll review this process in this video. Before you can apply to Tarion for qualification for enrollment to build and sell your project, you will first need to have a valid license with the HCRA. Once you have your license, you can apply to Tarion. Even though you cannot apply to Tarion before having your license in place, Tarion is happy to provide guidance to any applicant who is in the process of achieving their HCRA license. You can contact Tarion and we will walk you through the application process, provide you with the documentation you'll need to complete, and we'll give you a sense of what you can expect while going through the application process. Generally speaking, for common elements parcel of tied land, vacant land, and low-rise applications, you may need to provide the Tarion application document, which will feature a series of risk-based questions, information about the type of project, the location of the project, the size of the project, and financial questions, vendor-builder agreements, a request for a guarantor, and in most cases, they will be required to complete a personal net worth statement and provide the supplemental documents to substantiate the assets that they're indicating on that statement, as well as a new guarantee and indemnity agreement, and financial information, including statements for the applicant, will also be required. In addition, we require a condominium profile form, which is a separate application that is specific to condominiums, which helps us to confirm the type of condominium project being built. In most cases, we will also require the declaration and disclosure document, and we understand that these are in draft format at this stage, which is acceptable, as well as a sample template of your agreement of purchase and sale. If you're unsure of what documents you need to supply, please contact us and we can walk you through that process. Depending on the size of the project, we may also require drawings and a budget for all costs of construction, and we may also require a letter of intent from a financial institution. We may also require additional information in the event that the registered owner of the land is not the same person as the vendor. The vendor who is applying for the project should be licensed with the HCRA and should also be the same entity featured on the agreement of purchase and sale as the vendor for the project. The vendor should also meet the Ontario New Home Warranties Plan Act definition of a vendor, which is a person selling the units on their own behalf, for their own purpose, and who is benefiting directly from the sale of those units. For example, the vendor should not be acting as an agent for another entity, because then the vendor would not be acting on its own behalf in selling the units. As of February 1st, 2021, even if a vendor or builder was licensed previously, we still require new vendor and builder agreements, as well as any new guarantee and indemnity agreements. These documents have been modified to accommodate Tarion's new role, which no longer entails licensing, as we stated earlier, and we always encourage individuals to review them with their lawyer prior to signing. On a case-by-case basis, we may require additional information to assess the application, and when we speak with you individually, we will get a better sense of what we may require. Once a license is in place, we take all the information provided and conduct our risk assessment, which focuses on 3 main areas. The first area is financial strength, having the ability to complete a project that's being proposed. So access to capital, what type of equity there is, falls between the applicant and the guarantor. And if they have any other assets to capital, what type of equity there is. Basically how the applicant will finance the build. Also, what is our assessment of what equity or assets that will be available to meet warranty obligations? The second area is the technical piece, and this is not to be confused with the HCRA process. As part of the HCRA licensing process, they conduct some technical due diligence, and they're looking at builder education in a general sense. But what we're looking at is whether we believe you have the experience to construct the type of project you're proposing, which may require a different skill set. So for example, different project management skills managing a 300 unit versus a smaller project. The final area that we focus on is history, which may include any Tarion history. So anything we have recorded, such as past builder experience, any other experience outside of Tarion, for example, any past construction experience, maybe renovations, and in some cases, we may consider such experience if we're able to. We can also inspect or conduct walkthroughs for other projects that you've built, and we can also conduct reference checks to gauge previous client satisfaction in previously built projects. These would be assessed on a case-by-case basis and would only be feasible and add value if in Ontario. We have also on occasion interacted with other home construction authorities across the country to better understand your construction experience, which is another resource available. For example, if you built in Quebec, we may get a statement from or do a reference check with the Quebec authority. Construction experience in jurisdictions outside of Ontario may be considered by Tarion as relevant experience, but only to the extent that the regulatory and warranty environment is similar to Ontario's. An interview may also be required as part of this process for any new applicant that doesn't have a recent Tarion history. For example, you could be brand new and haven't built anything residential in Ontario yet, or perhaps it's been several years since you've had an active license, and we may elect to conduct an interview. This is because of all the changes with the Ontario Building Code and all the recent changes at Tarion, and we want to get an idea of your knowledge level and what type of construction activities or areas you've been engaged in the past few years, which is also something we would look at. If there's been a change in control within your organization, in other words, if historically we've relied on the expertise of an individual that is no longer part of your organization, we may want to revisit our assessment of your organization's current expertise, or for any other reason that we may have concerns about, we may wish to speak with you based on your past history. If an interview is required, you will be notified early in the process. Once the application has been submitted and we have conducted our review, the interview will be flagged and scheduled if it is required. It's also important to keep in mind that interviews and site visits are rare, but we may need to get a sense of your experience, and so we may require a site visit, which will add time onto the application processing time, which is dependent on many factors and can be expedited by proactively communicating and submitting all of the required documents. Once everything's been done, we're ready to issue the letter. Before we go over the terms and conditions, we want to review the definitions of the types of condominiums projects they apply to. A common element condominium corporation is a type of condo corporation with common elements only and not units as defined by the Condo Act. A parcel of tied land is a freehold parcel of land or a unit that a home is built on and the owner owns. A parcel is tied to an interest in the common elements. Common elements are not covered by warranty, and they typically consist of roads, etc. A vacant land condominium is the only type of condo that can be registered before constructing an actual unit on the land. Units cannot be sold, as per the Act, until the project has received draft plan approval. Common elements are also not covered by the warranty. We consider a low-rise project any project that is not comprised of any Ontario Building Code Part 3 components. Before we review the terms and conditions, we wanted to remind you about Registrar Bulletin 10, which is available on Tarion's website and contains a detailed overview of this process. Vendors and builders are encouraged to review this bulletin in its entirety. There are also other registrar bulletins that you should review, as it's your responsibility as applicant to be as familiar with all the applicable registrar bulletins, which can be found on our website. Once we've done our review, we're in a position where we can issue our terms and conditions, and generally speaking, the terms and conditions are set out in a document that outlines the parameters under which one can build and sell projects, as well as any other obligations that must be met throughout the life cycle of the project. The life cycle of a common element parcel of tied land is from the time the conditions are accepted by the vendor until the units close. It's important to note that as of February 1st, 2021, all vendors have been receiving a terms and conditions letter called a Notice of Proposal of Conditions. Once you, as vendor, satisfy those conditions, Tarion will issue a written confirmation or QFE confirmation before you can commence sales, which is to offer or agree to sell units or a home. A second written confirmation, enrollment confirmation, will be issued before you can commence construction. It's important to know that the terms and conditions letters outline the conditions only, and it is not confirmation from Tarion to sell and build. In order to sell and build, you must have written confirmation from Tarion to do so. These confirmations are provided by Tarion only after the conditions are met. The terms and conditions letter is different than before February 1st in the sense that we no longer require a sign back. Previously, when we issued our letters, in order for the application to be processed, there was a requirement for the vendor to accept the letter by signing it back to us. Another difference for all condominium letters is that we reference the common elements number now, and units must be enrolled and linked to that common elements enrollment number. However, as mentioned previously, common elements are not covered for common elements and vacant land condo projects. The letter now functions a little bit differently too, and once the terms are issued under the legislation, you have 15 days to appeal the conditions through the License Appeal Tribunal if you disagree with any of the conditions. If the terms and conditions are not appealed, it is considered that you have accepted the conditions, so it's very important to make sure that Tarion has the correct underwriting contact information on file. It's very important to read the letter carefully, and we do encourage you to call us to review the letter with you and to explain the conditions and how it all works. Another way to accept the terms and conditions, if you're in a position to expedite the process and don't want to wait the 15 days, is you can send us an email, which must be from a signing officer, to say you've accepted the terms and conditions, and then we'll proceed. The conditions within the common elements parcel of tied land, vacant land, and low-rise condominium terms and conditions letter are similar to what you've seen in the past, in that the letter continues to define the parameters around which one can build and sell, like the number of units and security requirements. However, the conditions are now categorized into 3 categories, which are the qualification for enrollment conditions, or QFE conditions, the enrollment conditions, and the specified conditions. The QFE conditions are any conditions that must be satisfied before commencement of sale. For standard condominiums, security will always be required prior to confirmation of sales. The enrollment conditions are conditions that must be satisfied before construction commences. And specified conditions are conditions that must be satisfied continuously throughout the life cycle of a project. So from when the conditions are accepted by the vendor up until the units close. An example of this is our annual reviews for our files, including financial history, performance, etc. For vacant land and common element parcel of tied land condos, the security assessment will be very similar to the freehold process from a securities perspective, because the common elements are not covered by the warranty and we are just looking at the units. As mentioned, for a standard condominium, even if it's low-rise, which is rare, we would underwrite to factor in that the common elements would be covered under the warranty, so the security requirements would be higher, which generally speaking could be anywhere from $20,000 to $40,000 per unit based on your experience and history. The common elements caps would apply to standard condominiums, whether it's a low-rise or a high-rise project. Securities may be listed under this conditions section, so if you want more insight into how we calculate securities, feel free to contact us or refer to the applicable Registrar Bulletin 11 on our website. There is no confirmation for specified terms and conditions because it is expected that you will keep performing these conditions throughout sales, construction, and until closing. For example, it's not a one and done type thing like posting security, where we can give a vendor a confirmation after posting security. Again, we want to remind you that it's important to note that the letter outlines the conditions and it is not confirmation. In order to sell and build, you need to have confirmation from Tarion to do so. Once you achieve QFE, and once those conditions are met, Tarion will give confirmation and then you can commence sales of the units. Once you achieve the enrollment confirmation, Tarion will give you confirmation and you can start building the project. In rare cases where units are being built before sold, the QFE conditions may not be required. If that is your intent, please contact Tarion to discuss because it may be worthwhile applying for the QFE anyways in the event that the circumstances change, which will give you more flexibility, but this is looked at on a case-by-case basis. With respect to enrollments, units are due to be enrolled 30 days prior to commencement of construction. Enrollments can be submitted through BuilderLink like they can be done today. All enrollments will be reviewed by Tarion to ensure that the vendor had obtained qualification for enrollment confirmation, if applicable, or has met all the conditions. If all conditions are met and all fees paid, which are due to be paid 30 days before construction commences, Tarion will provide the vendor with the enrollment confirmation, which will be the new enrollment confirmation, certificate of completion and possession, and warranty certificate. Once you obtain enrollment confirmation, you can proceed to build the units. There are sometimes cases where the vendor and the declarant are separate entities. The declarant is the entity under the Condo Act that is the registered owner of the land, and the vendor is the licensed entity that wants to sell the project. Sometimes the two are not the same, and the risk for Tarion is that since we have no jurisdiction over the Condo Act, if the declarant is separate, we have no jurisdiction to enforce that they are acting in accordance to the Condo Act that would impact the warranties. So for example, the requirement to hold deposits in trust with an escrow agent and the ability to transfer title to the purchaser, which is a requirement of the declarant under the Condo Act. But if the vendor is not the declarant, there is a bit of a disconnect, which can be challenging for us. We want to make sure that the entity that is vending the project, which is defined under the Act, has an entity or a person that is selling a property for its own purpose on its own behalf and is going to be directly benefiting from the sale of the units. In other words, if there's a situation where someone is acting more like an agent, so for example, conducting the sales, working on a fee, and ultimately everything goes back to the declarant or the developer, that would not meet our definition of a vendor, and that would be a challenge for us. We do have clauses in our terms and conditions to confirm that in cases where the declarant is not the same as the vendor will adhere to the Condo Act and will be able to effect title transfer from a declarant to the owner, something we look at to make sure the vendor entering into the purchase agreement and who is responsible for warranty coverage will be able to complete the sale. We also ask for a development agreement, which is a document that outlines the declarant and the developer and the roles and responsibilities of the declarant and the vendor so that we understand the relationship and we also understand what each party is responsible for. This helps us to understand who is doing what and who is benefiting from what. If there are concerns, we will discuss that, and if we are uncomfortable that the vendor doesn't meet our definition, we may require the signature of an officer certificate from a signing officer of the vendor, which is an attestation that they are acting on their own behalf and will be profiting financially from the sale of the transaction. And unfortunately, if they cannot attest to this, or if there is confusion to that effect, we may have an issue proceeding to grant QFE or enrollment confirmation. Organizational structures can also get complicated, so it's important that we know who the vendor is, and if the proper entity isn't licensed, this can cause delays, and this can be prevalent in high-rise construction as well. Where the vendor and the builder are separate entities who plan to work together to sell and build a home, the vendor may apply the previous steps to obtain the approval to sell and build. If you are licensed only as a vendor, you will be asked to provide information about the builder who will build the proposed project. Both parties must sign the applicable vendor and builder agreements with Tarion. The vendor should submit the application to Tarion and the terms and conditions will be issued to the vendor. Only the vendor can sell the home, which is to enter into purchase agreements and subsequently transfer title. and only the builder can perform the construction of the home and act as the builder throughout the course of construction. If you have any questions about the Tarion application process, please contact our underwriting team and we will be happy to assist you.